Mr. Carey, I've got a bunch of, I don't know, names in my waiting room here that aren't matching up to the cases I have, so it might just be a minute here. I got to sift through this and figure out who everybody is. So if you could just
let me
hold on.
explain one of them to you. Blake
Okay.
Erickson. Blake
Yep.
Erickson is with our firm. I've been having some connection problems with the internet, so he's just kind of a backseat to me in case I lose you.
Okay.
Okay.
Good.
That's the only one I can explain, though.
Okay, that helps. So that's one.
That's one.
All right. On Chuck's iPhone, are you Mr. Hewitt?
Yes, sir. Yes, Judge.
All right. Counsel, for Zoom hearings, it's really helpful to me if you're an attorney signing in, if you at least use your full name, because it's hard for me to tell from Chuck's iPhone. You know, I guess I can surmise that that's Charles Hewitt, but for attorneys, I would expect that you make it a little bit more clear for the court when you're an attorney signing in on a case.
I will do so, Judge. Thank you.
All right. I appreciate that. Are either of you expecting a Kelly Brown or a Dwayne Hadley to be part of this hearing?
No, sir.
Sorry, Judge.
Is Kelly Brown's attorney.
Okay. Okay. All right. I think we have the parties for this file then. This is Shaw versus Stiles, case number 2311441. We have both counsel present by Zoom. I believe this is set for a status conference hearing today. Mr. Carey, if you could, on behalf of the plaintiff, or I'm sorry, Mr. Hewitt, you're here on behalf of the plaintiff. Can you give me an update based on what you view from the plaintiff's side here?
Yes, Judge. We've been attempting to schedule and hold depositions of our respective clients, but we've encountered on both sides several health issues. My client's been getting radiation treatment, and Mr. Carey's client had surgery, and we had to reschedule depositions to, I think, April 24th, I think, Bill? 22nd?
Yes, sir. That's right. 24th is the right date. Yep.
So things have been out of our control, Judge. So that's why things have been slowed up, delayed.
Okay. Have you guys participated in mediation yet, or do we have a cutoff date for that?
We've completed mediation unsuccessfully. I think we've really completed everything, as Mr. Hewitt implied, but for the deposition of the parties. And I think when we're able to complete those depositions under the trial docket.
Okay. How much time do you want the court to set aside for remaining discovery, Mr. Hewitt?
I would think 90 days past when we complete the depositions, because Mr. Carey identified through interrogatory some additional witnesses, but we wanted to hear from the defendants, counter plaintiffs, what their beliefs were with regard to what the testimony might be of the other parties. So we might be finished with discovery once we finish with the depositions of the principal parties, but there might be some need to take one or more others.
Okay, Mr. Carey?
Yeah, that's fair. That's a fair statement.
All right. I'm going to then just leave discovery open for an additional 90 days. I'll set it for a status conference at that time, and then we can set trial dates going forward from there. Any objection to that, Mr. Hewitt?
No, that sounds fine. Inappropriate, Judge. Thank you.
Mr. Carey?
I agree that will work.
Right.
Just fine.
Mr. Hewitt, any other dates that I can address for your side while we're on the record today?
I'm sorry, just any other what? I didn't understand the word.
Any other dates or scheduling that I could address for your side?
No, Mr. Carey and I get along quite well, and if some problem comes up, I'm sure if we can't work it out, it'd be a bizarre situation indeed.
Okay. Mr. Carey, anything else I can address for your side?
Not at all, Your Honor. I appreciate your courtesy in letting us appear by Zoom.
Same here.
Okay. Thank you. That's all for today. Both sides are free to disconnect.
All right,
Thank you.
Okay, Mr. Thompson, are you able to hear me okay?
Yes, thank you. I'm here with client Ms. Crook.
Okay. And Ms. Eckert-Crispell, are you able to hear me okay?
Yes, I am, Your Honor. My client is seated. And so periodically I may have to interrupt the court to have things repeated.
Okay. All right, we'll go on the record then. This is Crook versus Crook, file number 2411820. All parties are connected by Zoom. And this is set for two matters today. We have a status conference as well as defendant's motion for temporary spousal support. Mr. Thompson, I had a chance to review your motion as well as your response, Ms. Eckert-Crispell. Mr. Thompson, is there anything you wanted to state by way of oral argument today on that?
Your Honor, I would tend to agree with Ms. Crispell that an evidentiary hearing is appropriate. And again, given her client's hearing difficulty, I think that might be best accomplished in a courtroom. We'd be willing to, wait for the court to rule until there is an evidentiary hearing.
Okay, how much time do you think we would need to set aside for that, Mr. Thompson?
I think we could get in a half hour, Your Honor.
Ms. Eckert-Crispell, would you agree with that?
No, I think it's going to take a little more than a half an hour. I would anticipate probably an hour to 2 hours is what I would anticipate. That would be a better estimate, I think.
Okay. I'm just trying to get a sense, like, I think if we could do it, in an hour, I could probably have it set on a regular motion day here, which would allow me probably to get the hearing set faster. If we're looking at, 2, 3, 4 hours, then I would probably have to set it for a separate date. So, I think, just looking at the briefs, I feel like an hour would be enough time, maybe a little bit more than an hour, but I'm going to try and set it for an hour hearing. And then if I can schedule a little extra time behind it, if we need it. So I will set it for an in-person evidentiary hearing on the issue of spousal support. And I'll set that for the soonest possible date that I can get. In terms of the progress of other aspects of the case, on behalf of the plaintiff, Ms. Eckert-Crispell, are there any other dates that you want to set for scheduling today outside of the spousal support issue?
Not in the way of setting any court hearings, Your Honor, at this point in time. I think that it would be probably 90 days discovery that we would ask the court.
Any objection to that, Mr. Thompson?
No, I think that would be appropriate.
Okay, so we'll set discovery to remain open for 90 days.
Your Honor, if I could interrupt for just a second. On that note, if does the court believe that we would be able to have that hearing on the spousal support sometime in the next 30 days or 45 days?
I do, yes.
Okay.
Yeah, I'm hoping we can get it on for early April, beginning of April.
Okay.
Okay, discovery remain open 90 days. Is this a case that's appropriate for community mediation, or do you think that is there enough assets or issues that we would need an attorney mediator on this, Ms. Eckert-Crispell?
I'm going to defer this to Mr. Thompson. Him and I have started trying to have some discussions regarding solving the case. But there is substantial assets. It's just not real complicated as far as what they own. We're talking real property. We're talking, personal property assets. And so we're not talking about anything out of the ordinary, basically.
Okay, Mr. Thompson?
Yeah, building off that, I do think community mediation would work in this kind of case where we have counsel. I do think we're close to getting our arms wrapped around this. Each side has done the required financial disclosure. I have a couple little follow-ups. I know Ms. Crispell does as well, but we are largely able to understand the finances.
Okay, so I'll refer it out to community mediation. And then I'll set this for another status conference outside of the hearing on the spousal support issue. I'll set it for another status conference for the close of discovery. So we'll have a control date out there. If the parties are able to get things resolved by then we can use that as a date to enter judgment and take proofs. And if not, then we can address, what the remaining issues are and how to schedule going forward. Any objection to that, Ms. Eckert-Crispell?
No, Your Honor.
Mr. Thompson?
No objection, thank you.
Okay, Ms. Eckert-Crispell, anything else I can address for your side today?
No, Your Honor.
Mr. Thompson?
Nothing for today, thank you, Your Honor.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
All right, whoever's on the iPhone, Sprint 4 iPhone, can you tell me your name, please?
Angela Shimmel.
Ms. Shimmel? Okay.
Yes.
Ms. Shimmel, I have your hearing scheduled for 2 o'clock, so I'm just going to put you on hold until that time, okay?
Okay, I just wanted to make sure I could connect right.
Sure, no problem.
Good afternoon, Your Honor.
1 second, counsel.
All right, thank you.
Okay, all right. We'll go on the record in Brown versus Brown. This is file number 2411819. And Mr. Hadley, you're appearing on behalf of plaintiff, is that correct?
Yes, good afternoon, Your Honor. If I make my appearance, Dwayne Hadley, P57172, on behalf of my client, Kelly Marie Brown, who I believe is in my upper right.
Okay, thank you. And I do see Ms. Brown connected. I have this as set for entry of a consent judgment of divorce. Mr. Hadley, is that how you wanted to proceed today?
Yes, Your Honor, I would. I believe that you have the original proposed judgment of divorce. And I think everything is in order. Looks like Ms. Brown's muted, but I'm ready to proceed.
Okay. Ms. Brown, can you hear me okay?
Yep.
Can you raise your right hand, please?
Yes.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. And Mr. Hadley, you can proceed whenever you'd like to, taking proofs from your client.
All right. You are Kelly Marie Brown, is that correct?
Yes.
And Kelly, can you indicate to the court the date of marriage to Mr. Brown?
June 14th, 2016.
And do you know when you separated from Mr. Brown?
Absolutely. July 22nd, 2022.
Okay. And you did file this complaint for divorce in Crawford County, is that correct?
Yes.
And for jurisdiction, then you be correct, you have been a resident of the state of Michigan at least 180 days and a resident of Crawford County at the time of this filing, at least 10 days, correct?
Yes.
And you indicate in your complaint for divorce that there's been a breakdown of the marriage relationship, that the bounds of matrimony could not be preserved. Was that true at the time that you filed the complaint for divorce?
Yes.
It's still true today?
Yes.
Any chance of reconciliation whatsoever between you and Mr. Brown?
No.
And Kelly, at this time, are you currently pregnant?
No.
And you have filed a proposed consent judgment of divorce with this court, is that correct?
Yes.
It appears that that's your signature there for the judge to review.
Yes.
And it appears that Mr. Brown signed this as well.
Yes.
And even though he is incarcerated in a federal prison in Kentucky, you have been in contact with him, correct?
Yes, sir.
And you have seen his signature and you verify that that is his signature, correct?
Yes.
And there is not any spousal support claimed by you, and it will be forever barred if and when the judge signs this complaint for divorce or this judgment of divorce. Is that your understanding?
Correct.
And you also realize that, or let me ask you this, all of the debts and equities and everything that during the marriage between you and Mr. Brown have been equitably divided, correct?
Yes.
He has nothing that you are asking the court to order that he return to you, nor is there anything that you have that belongs to him.
No.
Just essentially want to go your separate ways and everything has been equitably divided.
Correct.
And so you're asking this court at this time to grant you a consent judgment of divorce, correct?
Yes.
And finally, it appears that you're asking the court to order that your maiden name of Meyer, Meyer, be restored to you. Is that correct?
Yes, please.
Judge, I don't believe I have any further proofs.
Okay, thank you. The court finds, based on the testimony of Ms. Brown, that the statutory grounds for divorce have been met. The court has reviewed the proposed consent judgment and finds that it is generally equitable and contains all the provisions required by statute. The court will grant the divorce. I will note for the record, this hearing was set for 1:45. It's now 1:50. Mr. Brown has not appeared, although he was served with notice of the date and time of this hearing. It does appear that his the proposed judgment bears his signature dated February 19th. So the court will sign the judgment with today's date. Mr. Hadley, anything else I can address for your side today?
No, Your Honor. I don't know if you needed to indicate, but her maiden's name is restored, correct, pursuant to the judgment?
I didn't look in the judgment. Is that in there?
It is, Your Honor.
Yes.
Yep.
Yep. So that will be effective today. So Ms.
Right.
Brown, want to take whatever measures you need to change your name and other documents. Okay.
Yeah. She appears to be very, very excited about that, and I appreciate that, Your Honor, very much. So.
Sure.
All right.
Okay. Thank you. That's all for today, and you're both free to disconnect at this time.
All right. Thank you very much, Your Honor.
Thank you, sir.
Right. Bye-bye.
Okay.
Feeling I know what happened on July 22nd, 2022.
For $200.
Okay, so we'll be off the record until 2:00. Is there
Hello? Hello?
Hello?
Hello?
Hello?
Hello?
The person on the phone with the last four digits, 4650, can you tell me your name, please?
Timothy Shimmel.
Thank you. And Ms. Shimmel, are you able to hear me?
Yes.
Okay, we're on the record now in Shimmel versus Shimmel. This is file number 2411808. The record should reflect we have both parties present today. This is a divorce action, and I do have a proposed judgment here in the file. Ms. Shimmel, did you want to proceed and get your divorce finalized today?
Yes.
And Mr. Shimmel, is that how you wanted to proceed too?
Yes.
Okay. Ms. Shimmel, do you still have property that's personal property that you haven't picked up yet?
Yes, I do.
Okay, when are you going to get that?
Well, the weather kind of played a part in it there for a while. I'm hoping to have it within the next 60 days or less.
Okay, Mr. Shimmel, is that okay with you?
Yes.
Okay, so I'm going to write that into this judgment here.
I have no issue with her personal belongings there or anything, Your Honor. There's no point in doing anything. Just try and help one another and walk away peacefully.
Okay.
So if she
And
needs
that's
longer,
what you've
that
done.
is fine.
Okay. And Ms. Shimmel, what I see on this document here is you're going to take the 2018 Ford Fusion vehicle. Is that correct?
Yes.
Is there a loan or debt associated with that vehicle?
There is a loan on it.
Is that loan in your name only or both of your names?
It's in both.
Okay, so are you going to refinance that into your own name then?
I'm trying to see if I can get it refinanced or if I have to just sell it
Okay.
for the payoff.
Okay, so let me write that in. How long do you think that's going to take?
That I'm not 100% sure.
Okay,
I
how
would
about
love
if we say within a reasonable time?
Okay.
Mr. Shimmel, are you okay with that?
Yes, Your Honor.
Okay, and then Mr. Shimmel, you're going to keep the home, is that correct?
Yes.
Is there a mortgage on that home?
Land contract.
Is that in both of your names?
Yes, it is. And I'm working on to refinance it.
Okay,
And like you said a minute ago, let's do a reasonable amount of time.
okay, Miss Shimmel, is that okay with you?
Yes.
Okay, I'm just writing here, so give me a second.
Mhm.
Okay, and can you tell me, Mr. Shimmel, what's the address of that home?
10842 Chase Bridge Road, Roscommon.
Okay, thank
486.
you.
Okay.
Okay. And I'm assuming, because that's land contract, you don't have a deed yet to that property, is that correct?
Correct.
Okay. All right, okay, so I'm gonna place both of you under oath. I'm gonna ask each of you some questions. The questions that I'm gonna be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So, Mr. Shimmel, I can't see you, but can you raise your hand and let me know once it's raised?
Okay.
And Ms. Shimmel, can you raise your right hand? Thank you. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I
Yes.
do.
Okay, thank you. You can both lower your hands. Ms. Shimmel, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Have I been? Yes, I have been.
Okay. In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you will not be receiving any alimony or spousal support. You understand that you would be waiving that forever and you could not come back later and ask the court for that.
Yes.
All right, and in terms of the division of any assets or debts, we've already addressed those things that we've talked about. Are there any other issues relating to the division of assets or debts of the marriage that remain for the court to decide?
No, not that I can think of.
Okay. Mr. Shimmel, have you heard all the questions that I asked Ms. Shimmel?
Yes.
Did you hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
You understand that as part of the divorce, you will also not be receiving any alimony or spousal support. You understand that you're waiving that forever and you can't come back later and ask for that either.
Yes.
And do you agree that all the issues regarding the division of any assets or debts of the marriage have been resolved between the two of you?
Yes.
Okay, the court finds that the plea is knowing, long week. Court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court finds that the judgment of divorce is generally equitable and contains all the provisions required by law. The court will grant the divorce. I've signed that judgment with today's date. Ms. Shimmel, you're asking to have your last name changed to Smith, is that correct?
Correct.
Okay, so as of today, because the divorce is final, your name will be legally changed. So you'll need to change your identification and other documents. Also, if either of you would like a copy of the judgment of divorce, you can contact the clerk's office here in Grayling to arrange to get a copy of that for your records. Ms. Shimmel, do you have any questions at all?
No.
Mr. Shimmel, do you have any questions?
No, sir.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Mhm.
Okay, council, we're on the record now in Walker versus Munson Healthcare Grayling. This is file number 2311516. If I could have you both put your appearances on the record, please.
Good afternoon, Your Honor. Rebecca Filiatro appearing on behalf of the plaintiff.
Good afternoon, Your Honor. Nick Rizzo here on behalf of the defendant.
Okay, this date was set as a final status conference. I believe we have trial dates set for next week. Ms. Filiatro, are we going to be proceeding with trial?
No, Your Honor, we settled the case. We have agreed on the language of a release, and I'm just waiting for the final lien to come in from Optum for United Healthcare. That's the last piece of the puzzle before I can have my client sign all the settlement documents and get them over to Mr. Rizzo.
Okay, Mr. Rizzo, is that accurate from your standpoint?
That's my understanding, Your Honor.
Okay. And then Ms. Filiatro, will you be filing a dismissal then?
Yes, as soon as we have the final lien, we checked on it. We requested the final on February 18th, I think right around the time that we settled the case. We sent a second follow-up request yesterday on the status of the lien. They said it's going to be about 2 to 3 more weeks, but I asked that it be expedited.
Okay. I think what I'm going to do is set this as just a control date so that from my standpoint, the file just isn't open with no next date. So I'm going to set a control date status conference for 60 days, assuming that the dismissal will be filed prior to that, and then the court will take that date down. But if for some reason there's some issue that'll have a next date for us to meet to figure out what's going on and to see if there's something the court can do to help get things resolved and close the file. And then the court will adjourn the trials set for next week based on the party statements here on the record today. Ms. Filiatro, anything else I can address for your side?
No, thank you, Your Honor.
Mr. Rizzo.
No, thank you, Your Honor.
Okay, that's all. I appreciate counsel being able to resolve this short of trial, and you're both free to disconnect at this time.
Thank you. Have a good day.
See, Mr. Vernon is showing this. But yeah, if you can check and see if Mr. Collins. This is
On the PPO, but there's a status conference on the divorce case. And both are set in person.
Okay.
Mr. Vernon, we're checking to see if Mr. Colin is out in the hallway, but we did have this set as an in-person hearing.
Mine says it by Zoom. It was changed. It was an April hearing scheduled by Zoom. And then.
That's the.
So the first case that was set today was at 2:15. That's the.
Oh, yep, it is. It was noticed today. I assume Jen put it on Zoom, but it shows up in person on the docket.
Okay, all right. Okay, so Mr. Vernon, the first matter that was up for today at 2:15 was the alleged violation of the personal protection order. Is that your understanding as well?
I was actually under the impression that there was only a 2:30 status conference scheduled.
Okay, I think what happened was your client obtained the date for a show cause on the PPO, but then never served it.
Right. Mr. Vernon, I called your client and told her it was ready to be picked up. She said she would be in either that day or the next day. It is still sitting on my desk for today's date that was never picked up or served.
So you filed
The judge signed it on 2/7, I received it on 2/12, and then called her on 2/12.
Okay, give me 1 second. So you filed the PPO or the violation of the PPO. Ms. Miller called you and said that it's ready to be picked up, which means you were supposed to get it and serve a copy of that on Craig. But you didn't do that. Okay, so what do you want to do? Do you want to continue with that, or do you want to withdraw your PPO violation?
Well, I wasn't aware of that. I was going to speak with you.
Okay. So, Your Honor, we would ask, I mean, obviously that hasn't been properly served. So what we would ask is that hearing be adjourned until such time as we get proper service, and then we can reschedule it.
Okay, so I'm gonna leave that ball in your court then, Mr. Vernon. To the extent that Miss Colin wants to go forward with that, I'll just ask that you obtain another date with my office and set it for another show cause hearing.
We will do that.
Okay. And obviously I signed the first one, so I'll sign the next one as well, but for the record, I'm not ruling one way or the other on this particular instance, and we'll address it later to the extent that you want to. So that leads us to the status conference in the divorce case, which is set for 2:30. We're a little bit ahead on that. Mr. Colin hasn't signed in on that yet, so I'm gonna take a break until 2:30 and then we'll proceed at that time, okay?
Thank you.
All right, thank you.
All right, we're on.
Mr. Collin, are you able to hear me okay?
Yes, Your Honor.
Mr. Vernon?
Yes, Your Honor.
Okay, we're on the record now in Colin versus Colin. This is file number 2411622. The record should reflect that all parties are present by Zoom video today. This is set for a status conference in this matter on the property division part of this divorce case. And so, Mr. Vernon, from the plaintiff's side, can you tell me where things are at in terms of dividing up the assets or debts and what we need to do for scheduling to get that part of the case resolved?
So we haven't made a lot of progress since the last time we were in court, and there were issues with discovery. Mr. Colin has provided that discovery to us. I think he dropped that off earlier this week. And I have that discovery. It looks like it's everything we had requested. So I think that's been satisfied. We have mediation scheduled next week, so we hope to make resolution there. I think this status conference was actually originally scheduled in April and got moved by the court. So unfortunately now it got moved to before mediation. So there's not a lot to report. There's not a lot of progress, but we hope to have some progress for you to report next week.
Okay, thank you. Mr. Colin, is there anything you wanted to add to that?
No, that seems to be accurate. I just was told possibly that the kids, my parenting time would be reinstated today.
Okay, I'm not sure about that part of it. Today, we're just talking about the division of your assets and debts. So the court is going to order that the parties proceed to mediation as scheduled. I will set this for another status conference following the mediation. We'll see where we're at. If it looks like parties are going to be able to agree on those kind of things, then we'll schedule accordingly. If not, then we can look at setting a date for evidentiary hearing to resolve any remaining property issues. Any objection to that scheduling going forward, Mr. Vernon?
No, I think that's appropriate.
Mr. Collin, do you have any objection to that?
No, Your Honor.
Okay. All right, I'll put that out in an order and get that to the parties. I will also send out a notice of date and time for the next status conference on the property issues. And all parties on this file are free to disconnect at this time.
Wait, Your Honor. There's a, are you still there?
Yeah.
What am I supposed to do to reestablish the parenting time? Because the CPS and the cops said that they're dropping the case, and they said that with this court today, we were supposed to reinstate it.
All I have on my docket for today is a status conference on your property issues. So nobody said anything else for a hearing today.
All right. That's all.
Okay. All right, thank you. Again, all parties are free to disconnect on this file.
Okay.
Okay. And you can just let that concludes the court's docket for today. The court will be in recess until